You can see that's where the bullet went past my client's head and into the headrest.
Wow.
Thank goodness my client ducked just in time, but
Where'd the bullet come from?
the guy who was experiencing the road rage, he was under the mistaken impression that my client had somehow cut him off. We're all aware that chat and GPT is not always reliable, and we hear about these cases where the court gets a brief and realizes that 5 out of the 7 cases that were cited were completely hocus pocus, made up by the investigator.
Is autonomous driving mode a defense?
You know,
I didn't do it, the car did. I thought if anything ever happened, I would use that as an excuse.
it's probably human nature that we all want to blame somebody else.
Yeah.
Accept responsibility, but I'm going to have a tough time when that case comes in. The other thing I would say to the young girls is that perseverance does count too. And remember, we really are in it for the long game, not the short game.
Welcome, everybody, to another episode of the Collier County Bar podcast, powered by Beyond the Briefcase. So today's episode is going to be on advocacy, empathy, and professionalism. My guest today is attorney Richard Treiser, a respected advocate in personal injury and accident law here in Southwest Florida. Rich has built his career on a simple but powerful principle that people matter, and their stories deserve to be heard. Known for his steady courtroom appearance and deep empathy for clients navigating some of the hardest moments of their lives, he brings both strategic skill and human connection to his practice. His commitment to ethical advocacy, professionalism, and community involvement has made him a trusted voice in our legal community and a meaningful contributor to the mission of the Collier County Bar Association. Rich, it's an honor to have you here today.
Matt, thanks for inviting me.
I promise. So Rich deals with enough stress in the courtroom. We'll keep today's cross-examination light.
Appreciate that.
So first off, I want to ask you, so in the space that you're in, what originally drew you to personal injury and accident law?
Well, it didn't start out that way. I actually was a commercial litigation attorney for most of my career. And frankly, there was a lot of fighting over nickels and dimes and not a great deal of personal satisfaction to me in terms of feeling like I was serving a worthy need. I did a lot of banking litigation, real estate litigation, landlord tenant, uh, pretty much anything that involved civil disputes.
Mm-hmm.
But I always did a smattering of personal injury. And the gratifying part of personal injury to me is helping people who are truly at a time of need, injured, uh, dealing with the medical world as well as the insurance world, and not sure what to do. Um, Insurance is a confusing subject, and most people really don't pay attention to it until they need it, unfortunately.
Right.
So, it's really nice in my world now to be just focused on a limited practice area that I truly feel I can give people some good guidance when they need it.
Well, was there a moment early in your career where you confirmed that you were in the right field?
Well, I don't know if there was one magic moment. It's kind of the accumulation of many years of getting hit over the head with some of the things that we lawyers have to suffer through.
Well, you said you used to dabble, which I'll
Right,
just use that term loosely because I say when someone's not doing more than half of their practice, they
right,
call it dabbling, right?
sure.
At what point did you exceed 50% of your practice in accident law?
I'd say really the past 10 years. About 15 years ago, I had the opportunity to be involved in a pair of cases that were pretty tragic. They involved two guys who got killed in water skiing accidents. And
At the same accident?
no, these were actually team sports that were one locally and one up in Alabama. And as a result of successfully resolving the local case, I was asked to co-counsel a case in Alabama that was surprisingly similar. Um,
Okay.
and
So it was a coincidence
yeah,
that they both are around the same time.
it was. But of course, in the legal world, many of our cases do get attention on a broader level than just locally.
Right.
And so this one happened to involve a regional office, a regional district of a competitive water ski team.
Okay.
So they knew about me up in Alabama. But even though that wasn't the majority of the cases I was handling, we litigators do get kind of deep into some cases, and each of these lasted for close to 4 years with appeals and things of that sort. So
Is
it
4 years
occupied
a
great.
long time?
Well, yeah, it's certainly a long time for the clients, a long time for these things to get resolved. Nowadays, most of my cases are resolved hopefully within a year and a half.
Before they go to an actual trial?
Yeah, before trial. Yeah. As a matter of fact, really, the vast majority of my cases now do get resolved without trial, without litigation. Um,
Now, 10 years ago, or even prior to
mm,
that, was that the case?
uh, no, I think back in those days with those kind of issues that I was just describing, those were cases that probably could not have gotten resolved without litigation.
I see.
Unfortunately, in the larger cases, it boils down for the insurance companies, I suspect, to economics and where they'd rather have their money invested um, as opposed to settling cases. A lot of that still goes on, and it obviously depends on the uh, severity of the injury and the size of the case.
Yeah,
Yeah,
I can imagine.
yeah.
Well,
But
there's back and forth. Who's got the deeper pockets?
sure,
Who's
sure.
willing to make a reasonable settlement offer first? And
Yeah,
how long does that get strung out?
and without being too corny about it, I have to admit that part of the appeal to me is a little bit of that David and Goliath thing. I do feel pretty connected with my clients, and in the type of work that I do now, it's usually pretty clear who's right and who's wrong.
Mm.
Um, so dealing with most insurance companies, I'm not going to be your typical plaintiff's lawyer and badmouth insurance companies. Many of them and many adjusters are reasonable, and to a large extent, if we on the plaintiff side treat them and expect them to treat us fairly, generally you get pretty close to a fair resolution. Um, Occasionally, you run into situations where, for whatever reason, um, our idea of reasonable and their idea of reasonable is two different things.
But that's the exception now,
Yeah,
rather
yeah,
than
I would say so. All of us deal with law office economics, and even the insurance companies who may be paying uh, greatly reduced rates to their law firms still have to bear the burden of
Mm.
litigation. So, if my attitude is to be upfront and make pretty full disclosure when it comes to trying to resolve cases. There's no reward for playing games, and that's something of the past. Hiding the ball doesn't
Well, I'm,
work.
I'm glad you said that because I don't go to court, and a lot of people listening to this don't won't go to court.
Right.
And there's this misconception
Yeah.
that the lawyers just rung up the fees
Right.
and it's self-serving. But from the client's perspective, they have a real issue that needs to be solved,
Sure.
and
Absolutely.
they need someone to advocate for them, but without throwing good money after bad.
Right. And unfortunately, I think uh, this side of the profession has been tainted uh, by a lot of the perceptions that people get from the media, particularly the ads that we see on TV.
Or here on the radio.
Or hear on the radio, or rumors that you hear from friends of friends, that aren't really accurate.
Yeah.
And I guess one of the points I was going to bring up with you is that we lawyers really have a couple different roles to play, and uh, everyone everyone has this impression that the only thing that lawyers ever do is go to court and yell and scream at each other,
Hmm.
and uh, under the general heading of being an advocate for the client.
Okay.
We, especially those of us who've been around for a while, remember the bar rules and the oath, uh, and there used to be this word contained in the ethics about zealous advocacy.
Mm. It was removed before the oath was
It,
revised.
it deserved to be removed, and yet I think it still lingers in the background of some attorneys' minds. But I wanted to um, make the point that we lawyers are not just advocates, and even those who are transactional lawyers aren't just advocates, they're also counselors. And I think that that role is every bit as important as being an advocate.
I'm
We,
really, really glad you brought that up. You see, so when I started my firm 10 years ago, the decision of what to put on your card or your
Mhm.
signature, is it attorney, attorney at law, or attorney and counselor at law, or counselor at law? And so I relate back to a clinic I did in law school where it was interviewing, counseling, and negotiation. And that was one of the most valuable classes I ever took because I don't have a counseling background. But when you shift the mindset to counseling your clients, it becomes more human
Sure.
of a interaction, and it gives lawyers a better name, especially if you're the recipient of good counsel. And
Absolutely.
even if that means counseling them off the ledge to say, I don't think this is worth you pursuing,
Sure.
or let's really get down to do a cost benefit analysis.
Absolutely. And so often, almost all the time, clients are coming to us not because they already know the answer or that they know the process. They are in need of some help understanding how these things work. That's why I think that communication with clients is critical. Keeping clients informed. I've really, it's shocking to me when clients say, well, their lawyer doesn't tell them what's going on or they don't know what's going on. I mean, it's their case. And, that's something that I think we all always ought to keep in the forefront of our mind. It's not my case, it's theirs. I can give them advice and I owe it to them to give them good advice. And I tell them that I'm not here to tell them necessarily what they want to hear, but, um, but still in the end, they deserve to know what's going on.
Yeah, and I always tell my team, don't hide behind your emails,
Mhm.
don't hide behind your desks,
Right.
and pick up the phone, invite the person in. With technology, how it's proceeded since COVID, it's been more acceptable to appear via Zoom
Right.
or to even meet with your clients via Zoom. And that translates into, we don't have a good internet connection, so let's talk on the phone instead.
Right.
And then you don't have that same connection with your client, and they don't necessarily know whether they can trust you.
Right.
So I think building that trust is key priority. Once you have their trust, then you truly you offer them your counsel.
I do not accept a case. I will not represent a client who I haven't met face to face. And even after, and I'm pretty liberal with my time. I don't think I've ever had a new client meeting that's been much less than an hour. Um, because people have a lot of questions, and even after you explain it, they may still need to hear it again. Um,
Well, they say that we need to hear things on average of 7 times before we remember them.
sure.
So we think 2 or 3 times is enough, but not always, even
No,
when it seems obvious to us. Well, I want to shift the conversation a little bit because personal injury work deals with trauma and high stakes.
it does.
How do you maintain emotional balance?
Well, sometimes it's not easy. I think we owe it to our client to be objective and professional, and I think we have to avoid the temptation that sometimes uh, we feel to get down to an emotional level that the client's feeling. Obviously, most of the time that doesn't really help, and being antagonistic with the uh, insurance adjuster or counsel on the other side is in the long run generally counterproductive. I know that clients and the public find it very suspicious if the the attorney on the other side is speaking to you privately or referring to you by your first name or you referring to them by their first name. But have a good relationship with uh, the opposing counsel or an adjuster is generally not a bad thing. In fact, it very often makes things go smoother, saves everybody a lot of time and money. Um, Being able to resolve things with the level of courtesy and respect um, is going to serve the client's interest a lot more than me yelling and screaming because the client's yelling and screaming.
Yeah, it's hard. I imagine you got better at this over the years in your 40 plus years of practice, but
Yeah, it does.
the client's energy can transmute to the attorney if the attorney's not aware of their own emotional being.
Sure. Yeah, but still, it's our job to temper that and make to help the client understand that it's in their best interest to have things go smoothly. Um, all the talk and all the advertising about armies of attorneys and going to war very often is what leads to these 4-year cases,
Mm,
and it appeals after the 4 years. Um, so you know, clients, you don't do them a service by yelling and screaming. Not to say that some cases don't deserve and are entitled to some pretty forceful and frank uh, representation.
hmm.
Many people are seriously hurt, and they are entitled to be upset and a bit indignant about situations that come up.
Yeah, that makes sense.
So we
Well,
we
how,
we need to put it a little bit
what
better.
are some, so you meet with all your clients in person,
That's right.
um, at least that initial consultation,
Yes.
and that helps you build trust.
But it comes as well as a continuing process. I contact my clients monthly, personally. I know that a lot of attorneys delegate that kind of stuff. Uh, and there is a lot that my paralegal and my legal assistant do to maintain the communication
Hmm.
constantly. Everything that we receive in terms of communication, letters, whatever, the client gets a copy. We send out an email um, so they see what we're receiving. And likewise, when we send out correspondence or any kind of uh, communication, the client gets a copy. So in that way, the paralegal and the legal assistant are handling that, but the client is seeing what's going on. And then on top of that, I don't just leave it to them. I want the relationship to be with me. I want the client to know that they have access to ask me questions and
Hmm.
to discuss issues or concerns they might have.
Yeah, that's good. That's a good way to manage the practice. Once a month, what's your average caseload?
I have a very low caseload. I really am not trying to be a volume office. I know that the big firms with stacks of associates and staff can have 100 or 200 cases. For me, 30 to 40 cases is plenty.
And to be honest, I mean, think 30 to 40 conversations a month in addition to everything else you're doing, because you're talking to other people in between all those calls with your clients.
Mostly. Yeah.
What advice do you have for some of the younger attorneys that maybe have these higher caseloads and they're starting to make their direct communication with the client secondary to their advocacy?
I just think that's a danger signal. I really am concerned when, and I do get some of the cases, clients who started with one firm and well, often because they're dissatisfied because they are not knowing what's going on or they're not informed or they don't feel like their case is being paid attention to. Um, those are the kind of things that lead to bar grievances.
So it sounds like a good question for your lawyer when you're thinking of hiring one is how many cases do you currently have?
Oh, absolutely. And I think the other good question is, am I going to have access to speak to you? Because in many of these high volume firms, clients uh, will tell you that they never have met their attorney. They've never even spoken to their attorney.
Hmm.
It's shocking, but again, I think it's an invitation for a bar grievance, and it's an invitation for an upset client. And frankly, I don't blame them because ultimately, we, the lawyers, are the ones who have the responsibility for the case. So, you can only delegate so much. Asking or expecting a legal assistant, someone who doesn't have uh, the education or the responsibility that we have, isn't going to make the client feel comfortable necessarily with the answers to the questions that clients may
Yeah,
have.
I agree with you. Well, let's talk about a little bit of inside the courtroom, um, where we're connecting facts, people, and persuasion. What separates an effective trial lawyer from a merely good one?
Uh, uh, Good question. All of us, who go through law school, I think are pretty imbued with the idea that you do have to be detail oriented and know your case and be prepared. But you can do all the preparation in the world, and you can know the case law or the facts. But if you don't present it in a way that uh, connects with people and makes not even just jurors, but even judges understand that you're talking at a human level with real human beings. Um, have a silly illustration of that. I prepare settlement demands that are submitted to insurance adjusters,
Okay.
and they may be anywhere from 10 to 40 pages long with all the details about the medical issues and
Hmm.
the accident, the liability. But I always include a personal background portion
Of your client.
about the client, and not just a bit of a bio, but also a picture of them. I actually take a headshot of all my clients when they come in that I include in my settlement demands. And I tell my clients the reason is I don't want the insurance adjuster to think of you as simply a claim number. I want them to think of you as a real person. Now, I bring that up because I think the same does apply in the courtroom. I think you have to let the judge and the jury know this isn't just another day of routine court proceedings. This is an important moment in the life of a real human being. So my point is, you need to you need to humanize the story, and there needs to be a story.
Well, have juror expectations changed in the last decade from your perspective?
You know, I'm chuckling because now in the past several decades, we see more and more lawyers on TV and all those shows that uh, are so dramatic and give people the impression of how things could work.
Right.
The sad truth is that no matter how good we may be in the courtroom and how great story we're telling, it's never going to fit into a 30-minute television show with commercials in between.
Yeah, wouldn't that be nice if you could
So,
fast forward through all the dead space, all the
yeah,
downtime?
sum it up. The truth is that in most cases you're just grinding it out, and there's certain elements of every claim that have to be established. There's a lot of paperwork and documentation. Along with every one of my 10 to 40 page settlement demands, there's usually 200 to 500 pages of medical records, crash report, uh, all kinds of documentation.
In
And
case they need it.
well, you have to be able to put your money where your mouth is. You have to be able to not just say it, but prove it. So having documentation is necessary, and it's necessary in the courtroom as well. It's nice if you can get past that and remind the jury or the judge that this all does boil down to a real human being in our situation who is injured and is entitled to be uh, compensated for their injuries.
Well, speaking of a real human being and real things, look, you brought something here to show us.
I
What
did.
do you have over there?
Well, this is my little show and tell for today. And what I have is
Looks like a Navigator,
yeah, actually,
Mercedes.
it's the headrest from a Mercedes, a really nice Mercedes. It was I think at the time, this Mercedes SUV was only a year old.
Wow.
And
And that's where the person's head was.
that's what his head was resting against in the driver's seat until the,
Let's see if you can show that up so anyone looking on the camera can see it.
yeah,
That's incredible.
you can see that's where the bullet went past my client's head and into the headrest.
Wow.
Thank goodness my client ducked just in time, but
Where'd the bullet come from?
uh, the guy who was experiencing the road rage, he had was under the mistaken impression that my client had somehow cut him off or
Oh my
bumped him.
goodness.
And it was purely innocent. I'm convinced my client had no intention, didn't even realize that he even was anywhere near this fellow who was merging onto I-75.
So
But
this did that cause the accident?
uh, no,
Because I know
no.
you're not a criminal attorney.
Well, we all end up with cases that are connected in one way or another. I actually
Okay.
was representing this fellow in a car accident, a previous car accident, and in which he was fairly significantly hurt.
So you would know whether it was a legitimate road rage incident
Oh yeah,
because
well
you already knew.
there was no question about this one. In fact, this fellow who was shooting at my client is now serving 17 years for attempted murder. But
Did that go through the windshield?
uh, yeah, well, the guy was not a bad shot. Yeah. But fortunately, as I said, my client was smart enough to duck when he saw the gun
Wow.
come out. This guy had pulled ahead of him after they got to the I-75 entrance and stopped. And my client thought that he was pulling over to do the right thing, which was to call the police to report that there'd been
Oh, because
an accident.
he hit each other.
Well, yeah, not only they hit each other, but Mr. Road Rage actually rear-ended my client after that to express his dissatisfaction that he'd been cut off.
Oh my gosh.
So my
Then he
client
pulled over.
really thought that they were just calling to report, goes to the police. When the guy in front of him got out with his Glock, that's when my client realized they weren't reporting this. He was ducking.
Well, I don't imagine you have too many props with quite a story behind it as that one.
One of the great things about being a litigator is that, over the years, there are usually some quirky cases that lead to an interesting story. But yeah, fortunately, I don't. That's my one road rage case. Um, as I mentioned to you before, I think it was compounded by the fact that uh, the shooter was on anabolic steroids and
Ah,
had a history of bad temper. Uh,
yeah.
he was
Well, that's advice to anybody that's driving in Collier County.
well, for sure. I strongly encourage people not to let their temper get the better of them when they're driving. And
So I got my first electric car in September, a couple months ago,
okay.
and I've been using the autonomous driving, full self-driving a lot. And
Mhm.
I'll be honest with you, I feel like if anything, that will help prevent road rage incidents. The problem is not enough people are have it on self-drive, because when I'm letting the car do the driving, I can just sit back and relax.
Right.
And it's smarter than it would react in some cases more appropriately than I would. Follows further behind, goes a little slower. I'm not advocating for electric cars, but everybody I've told this story to, I tell people that I'm all in because it is nice to just sit back.
Well, I'll tell you one thing. Doing the kind of work that I do has made me a much more aware as well. And there's a lot to be said for defensive driving because, as we know, Collier County roads, especially in the season, get to be pretty crazy.
It is I mean, it seems like twice a day now since the month of October, I've had to watch and just let people over. There's this
Mhm.
book it reminds me of I read. It's called Unoffendable. You ever heard of it?
No.
It has to do with, he used an example of being in traffic, and when someone cuts you off, you just don't take personal offense to it. So I think that you set your ego aside
Right.
and you have to think like, and then another way of looking at it is if you're supposed to do one good deed every day and you try to do it, letting someone over in traffic might be that
Right.
good deed.
Absolutely.
If everybody thought that way, And what I try to do is I use tunnel vision when I drive, even though peripheral can see things. I don't look over at the person that I knew was mad at me. Maybe it was a mistake I made, it was a bad turn, or that I am mad at. And that's my way of coping with the
Whatever it takes,
tempt to road rage.
random acts of kindness, just let it go.
That's right.
Yeah, one other point that might be of interest on that subject is surprisingly, many people are not aware of the existence of what we call the black box, the electronic data recorders that are now pretty standard in all vehicles.
Okay.
And so, if ultimate truth is needed, uh, you can pretty much find it
Is it audio?
on the black box. It's not audio, but it measures many aspects of engine performance.
Yeah, I thought that was only in airplanes.
Oh, no, no. As a matter of fact, that's what most people think of. But since the late 1990s, they started equipping vehicles with it, and now there probably not any vehicles without it. It will record the last 5 seconds prior to impact. It locks the computer. It saves 5 seconds prior to impact of a variety of engine performance data, which includes braking. It includes steering. It will record whether you're turning left or right, and most importantly, speed. So
And I thought they had to use tire tracks for speed.
no, no, that
Well, I just learned a lot on this conversation.
it's hugely valuable, and it does take a technician to download that information.
Which I'm sure wouldn't be hard to find.
Not at all hard to find, and actually, and not terribly expensive either. 500 to $1,000 will get you that information. So, I've had numerous occasions where I've had to resort to that. You know, most of the time accidents are clear cut, but sometimes they're not. And question of, were you speeding? And it's precise.
That's a little more than circumstantial.
Now, you really can't argue about the black box. Theoretically, I suppose there could be some kind of technical glitch, but normally that's pretty rock solid.
Is autonomous driving mode a defense?
That's
I didn't do it, the car did.
I haven't come across that yet.
I imagine you will someday. I thought if anything ever happened, I would use that as an excuse.
It's probably human nature that we all want to blame somebody else,
Yeah.
accept responsibility. But I don't know. I'm going to have a tough time when that case comes in.
Well, start preparing mentally for it now, I guess.
Sure.
But don't spend too much time on it until you have to. Well, I want to shift a little bit about when it comes to your involvement in the Collier County Bar Association.
Mhm.
How has your involvement shaped your practice?
Well, there are a lot of people, I have to say, who've been taking much more leadership responsibility than me and been more active. But uh, I've been here a long time, and I've seen the evolution of the Collier County Bar Association, and it's very uh, it's a very positive thing to me that it has grown and offers all the opportunities that it does now. We have great administration in the Collier Bar. The uh, professionalization of the administration is huge. And back in the day when this was a bar association, I think I was number 111 or 12
Okay.
lawyer, and now we have over 1,000. Um, and it is, back in those days, you could know everybody. It wasn't that difficult. Guys like you and I, me being a litigator and you being more of a transactional attorney, might not bump into each other, but even then, with 110, I knew most of those real estate.
Well, my conversation with Laird Lyle touched on this a little bit as well too, about involvement. Now we
Mhm.
know Laird's involved at the state bar and the local bar as well.
Yes, yeah,
You don't have to go that deep
no.
to reap the benefits of getting to know lawyers that you wouldn't otherwise see had you not gone to some of these events. And I agree with you on that.
Yeah, and the section meetings, we in the trial lawyers section have monthly meetings. Often they are continuing education led by judges, our judges. So that's a great opportunity to, get questions answered and just get a better feel for um, working with each other, which again goes back to some of the topics we were touching on in the beginning about courtesy and cooperation.
Yeah.
And I do think that plays a really important part in what the Collier Bar does in getting us together and realizing we are, one of the great things about Naples, to me, has always been that we're still a small enough community that you can have a personal relationship with most of your colleagues. And I come from the Northeast. I grew up in New Jersey and went to school outside of Philadelphia and law school in Boston
Yeah.
and those kind of places, you can be a jerk and you might not bump into this other lawyer who uh, you were being a jerk to. But around here, it's not the case. And on top of which, your reputation does precede you.
Well, it takes more energy to be a jerk than it does to be nice.
Well, that's for sure. And honestly, this is I think it's an honorable profession. I think it's important that we all act professionally. But the bottom line is, if it's giving you ulcers and shortening your life expectancy, it's not a great job.
Well, the first lawyer that taught me about mindful meditation was a trial practice attorney in Gainesville when I was at UF there. And this was in 2012, I think. And I thought that was interesting because I never heard of a grown man talk about meditating. And he was a senior attorney, very well respected. And do you have any practices like that that help keep you grounded?
25 laps in the pool twice a week and 3 days in the gym.
Okay.
And yeah, for me, it's just a personal preference to get it out of my system in the morning. It makes me
Well,
feel relaxed every
swimming,
day.
moving your body, that's a form of meditation,
Mhm.
right? It's a form of disconnection, getting the endorphins flowing. So that's good stuff.
I think the other thing though, and I'm kind of now outside this stage of life, but too often, and I lived through the parenting phase, and I really uh, placed a high value on um, having an opportunity to be involved with my kids growing up. I have two sons, and I'm very proud of them, and they've turned out to be pretty good human beings.
I'd say Eagle Scouts, both of them. I mean, that's a feat in and of itself.
Uh, you know, and I truly believe that parenting and involvement is key to our society evolving to a higher level. I wouldn't uh, trade the career or sacrifice my involvement in my parenting for my career. I think too often, we get so caught up because it's endless. You can never stop doing a better and better job the more time you want to spend on it. That there is a limit when it interferes with the balance in your life and your involvement in
Hmm.
the other things that do count. And you know, the parenting part of it to me does definitely deserve priority.
Well, if you were speaking to younger litigators today, what advice would you emphasize to them?
Well, I think that that's part of it. I certainly think that we all need to keep in mind that there is a healthy work-life balance. And, there are times for all of us where, if I had to get ready for a trial, I'm going to be working till midnight or 1 o'clock or two, just marking exhibits and getting things ready.
Right, but that would be
But
the exception versus the rule.
exactly, exactly. You still have to get home for dinner on a regular basis. You still have to take the opportunity if your kids are involved with baseball or Boy Scouts or soccer or whatever it might be.
Yeah,
And then
to show
usually
up.
there's a spouse involved too, so
Yeah.
uh, there are never enough hours in the day, and that's I think one of the challenges and the thing that causes a lot of us lawyers a lot of stress. But you have to find that balance.
Yeah, sometimes easier said than done, but you have to set that boundary and think about it. And some of us will learn the hard way
Well, at least be conscious of it, and when you're not able to do it, recognize that you're not.
and explain that to your family.
Sure. Sure.
So it's not a, um,
But I think the other, just to finish up on that point, the other thing I would say to young lawyers is that perseverance does count too. And remember, we really are in it for the long game, not the short game.
Yeah, that's
So
good advice.
I never thought much 40 years ago when I first came down here that I'd be sitting here today as an older attorney. I always thought I was the younger guy, but
Well, you still look pretty young, if that makes you feel any better.
well, I appreciate that. I'm sure it's
You have
starting my
hair on your head. That's a start.
but I think that the importance of realizing that uh, short-term things like you know the money or the last shot you get in at the other lawyer or the client isn't always serving you in the long run.
Yeah. I appreciate you saying that. That's really good advice. So let's shift the conversation a little bit to the future of personal injury practice.
Mhm.
Technology, AI, juror psychology, client expectations.
Yeah, yeah. The other the other challenge I think of our career is that we don't get to rest on our laurels. Maybe 100 years ago you got out of law school or out of whatever training you received and didn't need to learn much more.
Hmm.
Um, but it isn't now just a matter of keeping up with new cases and new statutes. Obviously, the technology is huge, and we should and can use it in good ways. I don't think it's a good way uh, when we are using it as a substitute for having a relationship, a real relationship with our clients.
Hmm.
Um, but it does it does create a lot of burdens as well because client expectations are instantaneous these days. People have kind of lost the uh, concept that things take time, including
Well, if they
input.
found an answer using Chat GPT, why can't you find it and get on the
Bingo.
phone and tell them what it is?
Absolutely.
When it comes to expectations, I deal with this all the time, and I say I have to fact check the same thing that you do, and you hired me to fact check it for you and give you counsel
Sure,
advice.
sure. And of course, we're all aware that Chat GPT is not always reliable, and we hear about these cases where the court gets a brief and realizes that 5 out of the 7 cases that were cited were completely hocus pocus, made up by the computer.
Yeah, I'll tell you.
That's scary.
I don't know if they teach shepherdizing in law school today.
You would hope so, and you'd hope that lawyers still remember how to do that, make sure that they're quoting good authority. Uh, the other thing that's troubling to me, though, is the politics that our profession is now uh, being subjected to. In my field, particularly,
Give me an example of that.
well, what I have in mind is tort reform that came out recently that um, changed a lot of things. And in my, from my perspective, I think that the insurance industry had a huge influence on the legislation.
Is this why we're seeing more and more lawsuits? Like I get a mailer, it seems like once a month that I'm part of a class action that I could benefit getting $5.60 from,
Right,
and the
right.
settlement's 8 million or some much larger number.
Yeah, well, yeah, class actions have kind of a life of their own and a whole
So
other.
that's not the same as mass tort litigation.
Uh, no, it can be, but the tort reform that concerns me the most is not giving people a fair chance to know the extent of their injuries
Okay, so
before being forced to file a lawsuit.
so that's self-serving to the insurance companies.
Totally.
That's right.
There was a statute of limitations in Florida all these years that was reasonable, quite reasonable. It was 4 years. The recent legislation reduced the statute by half. It's now 2 years. Um, it probably not a surprise to many people that the type of injuries you can get in a car accident it can require treatment that goes way beyond 2 years. And I've had clients just completely
So tell
surgery.
me, so walk me through that. If the statute of limitations is 2 years and they plead their case and settle it, they can still go beyond 2 years for damages and right.
Well, no, that's the problem. The first step in the process is trying to avoid litigation to begin with,
Okay.
and yet we're really being denied, the client and the
So
public
you
are
think
being
it's
denied that opportunity.
might create more litigation
Oh,
because
absolutely,
they have to jump
absolutely.
faster?
When they passed this law, the effective date in March of 2023, there was a uh, huge wave of lawsuits that were filed because they were forced to. Um,
As opposed to the soft approach,
sure,
non-adversarial, let's see what we can do to work this out. Here's what's
absolutely,
going on.
absolutely.
Versus you have to now serve them with a lawsuit for them to take you seriously
Well,
and preserve your right.
and of course, the problem is that in certain cases, not uncommonly, the this person who was injured in the car accident does not know the full extent of their injuries or the full amount of treatment that's required.
Mm,
Uh, Often, what I deal with are spine injuries. And it's very common to have cervical or lumbar injuries as a result of car accident. And so, one of the main things that happens, and and nobody in their right mind wants to have spine surgery. No one's going
right.
to rush to do that. Yet, uh, there are a lot of conservative treatments that are often tried, attempted, uh, before that last choice has to be exercised.
Hmm.
And this two-year statute of limitations, in my opinion, is forcing people to file a lawsuit before they even uh, know whether they're going to be going through surgery or living with some debilitating injury the rest of their life.
So what are some of the ways that you would deal with this new change and how you might approach something differently today after this new tort reform?
Well, I am very clear with my clients, usually in the first meeting, that we're now under a new timetable and that they do need to be uh, prompt about not only getting medical attention,
Hmm.
but also make decisions um, probably sooner instead of later. Uh, because even if you decide you are having surgery, that's come only after months and months of other treatment. And then you have to get it scheduled. And then after you have the surgery, you have months and months of recovery. Most injuries, most surgeries,
Hmm.
most doctors will tell you are going to take up to a year before you reach, full recovery.
Hmm.
So rehab after surgery is still an uncertain time.
And so do you have to speculate then? I mean,
Oh, sure,
what
absolutely.
data do you have to back up that this person's going to need?
Well, you don't, and what happens is lawsuits get filed, in my opinion, prematurely. Not premature by law; they have to be filed, but prematurely in the sense that the lawyer and the client haven't really had an opportunity to assess um, how severe this injury is and what future treatment they may need.
Hmm.
So, yeah, you are filing without knowing, and then just hoping because the time frame for getting a case to trial is usually at least a year and a half, more likely two
Hmm.
or more years. Um, you're expecting that the client's going to continue to recover or get additional treatment during the time the case is pending. So you're filing a lawsuit while they're still getting treatment.
Yeah, that's difficult. I didn't realize
It's
that.
not ideal. It's definitely not ideal. I think it backfired a lot of ways. Yeah, there's this sense as well that PIP has been abused.
Personal
Florida no
injury
fault.
protection.
That's the $10,000 that is required of all uh, to register a vehicle. You have to have PIP insurance, personal injury protection, no fault insurance.
Okay.
So that pays the first 10,000 of your medical bills, whether the accident was your fault or not.
Hmm.
Um, but there's been a strong push to do away with that, which I think is a mistake. I think the justification is that they feel that there's some in the medical community and perhaps on the legal side too are taking advantage or abusing the $10,000. But for many people, that $10,000 gives them the opportunity to get medical treatment, the immediate medical treatment they need, and that was really the theory behind the law to begin with. Um,
I sat in on a couple mediations in law school where it was on the policy minimums, or I don't know if it's called the limit,
mhm, Limits. Mhm.
and it was either a quick case for a soft tissue injury
Mhm.
at the 10,000 mark,
Right.
or you would say this is much worse and this is what my client would accept today, but we're not dropping everything.
Mhm.
We're just going to start here.
Yeah, yeah. Well, unfortunately, there's no such thing as a, um, at least on the personal injury side, as a partial settle. You're either
Okay.
settling or you're not,
Okay.
and you're going to, and no insurance adjuster in the right mind is going to give you a check without getting a release in return.
There's no partial releases in those cases?
No, no. Yeah, you can settle the property damage side without affecting the personal injury side,
Okay, so they could
or vice
bifurcate
versa.
the
Yeah, that is
damages.
almost always bifurcated. But I will add one bit of um, warped legal humor or medical humor to this, which is um, the old adage about what's the difference between a minor injury and a major injury. It's minor if it happens to you, it's major if it happens to me.
Hmm.
And of course, from the insurance adjuster's point of view, they're all minor injuries, but most of my clients think they've got major injuries. And again, that's where counseling comes in, and we do have to put this in perspective so that people can make reasonable decisions. But in the end, the goal is a fair result,
Yeah.
not the pot of gold at the end of the rainbow, but it's also not being uh, treated poorly or not being treated fairly.
Yeah. Well, what do you often find that clients have unrealistic expectations usually when they come see you at first?
I think there are many people out there who do have unrealistic expectations, and I am very uh, incensed on the occasions that I hear that there are lawyers who will guess and give their client a evaluation uh, the first time they meet them.
Hmm.
That's ridiculous.
Well, that I think that goes with client expectations,
Sure, absolutely.
where you
Yeah.
got to manage that, and
Mhm.
it's becoming harder with more attorneys willing to give a number to a case in that first. I've
Yeah,
heard that before. Yeah, another lawyer estimated my case was worth about this.
yeah, yeah.
And you're telling me this,
Mhm.
and all of a sudden you're not as good of a lawyer than the other guy
That's
because
right.
you're not willing to spend out a number in that first
Sure.
introduction.
And unfortunately, people have short memories, and then a year and a half later, when the case settles, and it's nothing close to what they were promised or led to
Mm,
believe. Um, but I like to follow that rule about under promise and over perform.
yeah.
I'd much rather a client be pleasantly surprised than disappointed.
I
And
think that's why you lasted as long as you have in this area of law, I think.
well, I think that's unfortunately why some clients end up again filing bar grievances, and that'd certainly be part of my advice to young lawyers is don't don't blow smoke. Don't tell people what they want to hear. Tell them what you professionally know is the right thing, which
Yeah.
is which is you can't fairly evaluate a case. A death case, maybe, but cases that involve medical treatment and
Hmm,
long-term treatment, no.
interesting.
Yeah.
Well, that's good to know. I get those questions all the time. My wife's a doctor,
Hmm.
and there's a reputation. She works in the emergency room. They get sued all the time. I know you don't deal with accidents, but those attorneys seem like they throw everything under the sun, name everybody.
Yeah, unfortunately, and I think that's the nature of pleadings these days. You're right. I don't deal with malpractice, but I know that the ER docs have a tough job to do, and frankly, I think they're misused more than they're used appropriately by a lot of people. People
Yeah,
go in there for a cold,
or
or
pain meds,
yeah, right, right,
drugs, basically.
and honestly, I think that the ER docs serve their serve the highest calling of their profession and do their job when the person walks out of there alive. That's mainly
It's a good point.
there for emergency, real
Emergency
emergencies.
solved.
Yeah, exactly.
You're alive.
And then they refer them to for further treatment.
Yeah.
But to go into the ER because you've got a backache, or I mean, you're in the wrong place. It's just the wrong. And unfortunately, once you're there, I think that the ER docs have an obligation to check every possible
Yeah.
issue, even
MTEL
no
up.
matter how remote. So
Yeah.
the bills get expensive, and then everyone resents the fact that the hospital is billing as much as they are. But
And then they classify all plaintiffs' attorneys in one
sure,
class,
yeah,
one group.
absolutely. But I I generally, unless my client is bleeding, missing a limb, missing a bodily function,
Yeah.
um, I'm not a big advocate for them going to the emergency room if they don't really need it. So obviously, many cases do, but I do see a lot that don't.
Well, let me ask you, as we start to wrap this up, some of these questions, looking at this theme of like legacy, right? What does
Mm.
legacy mean to you? When you look beyond verdicts and settlement, what does legacy mean to you?
Ah, well, first of all, legacy means you're getting darn old. Because I can absolutely assure you that that's not a word that was part of my vocabulary or thought that crossed my mind for uh, at least the first several decades of my practice.
Okay.
But I am at that point now, and I have gotten a little more philosophical and nostalgic, and so I guess I do have an answer for that, which is, you know, all of us would like to change the world and make it a better place. At
Hmm.
least most of us, I hope. Um, but the truth of the matter is, no matter how good we are, and I think we all picked a good profession to be in because we can do a lot of good, but we do it one at a time. And I over the years, many of us who've been fortunate enough to do this kind of work have had those cases where you do see uh, your work having a real impact on somebody, and 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 again, it's not about necessarily the number of zeros after the dollar sign.
Hmm.
Um, I've uh, had some pretty uh, good uh, satisfaction, professional satisfaction, from handing a client a check for $20,000 or $30,000, more than what I've handed other clients a check for $1 million or two. Um, it really is a matter to me of you know nice to think that in my legacy, I have a few people who would say, you really helped me.
Always doing the right thing, even if that means taking a loss or not trying to knock it out of the park.
We all get our turn at some point. If you hang in there long enough, you persevere,
Yeah.
and good cases, good fee cases will come along, but you don't measure it uh, case by case that way. And every case, you ought to be doing the best you can, um, regardless of whether you're making a lot of money or you're not making a lot of money.
Yeah. Well, this is kind of bringing us to the end of our time here. I really appreciate you and also the Collier County Bar for sponsoring these and allowing us to come together, have these conversations. We have a surprise lineup of other attorneys we'll be interviewing, so I look forward to that. And what we're doing here is we explore law, leadership, and life beyond the briefcase.
Mm. Matt, thank you for having me. I really enjoyed talking to you.
All right, it's a pleasure.
Yeah,
Thanks, Richard.
welcome.